Rise. For the Honorable Judges of the Caribbean Court of Justice.
Director of Public Prosecutions. Members of the judgment delivery panel are the Honorable Madam Justice Rajnath, presiding judge, the Honorable Mr. Justice Baru, and the Honorable Mr. Justice Jamda. Counsel, you may now enter your appearances.
May it please your honors. Nigel Hughes, along with Ronald Daniels, Kiswana Jefford, and Savannah Barnwell for the applicant.
May it please your honors, Diana O'Brien together with Mrs. Shalimar Ali Hack, Senior Counsel, and Mrs. Tishana Lake for the respondent.
Thank you all, counsel, and thank you for all those who have remained on to see the court in person. It is indeed a pleasure to be in Guyana and to see the familiar faces that we've only seen through a little screen from my home office since 2020. So I'm delighted to be here, and so are my brothers. In this matter, the appeal was authored by Justice Jamada. I think many of you are aware that Justice Jamada arrived in Georgetown this morning. So it is my pleasure to read a summary of his judgment. And we want to say in this matter, we have anonymized the entire proceedings at our end so that in accordance with best practices to protect the complainant in this matter. And as you're well aware, this summary is just a summary of the judgment, and it's not to replace the judgment. Thank you. Yes, certainly, Justice Jamada raised an important point, which we ask the media, please. We've called the matter AB against the DPP, and we would really appreciate if that, from now on, the matter is referred to as that, because we must bear in mind there was a child involved. Thank you. The applicant was charged and convicted of 2 counts of sexual activity with a child, contrary to the Sexual Offences Act of Guyana. It was alleged that he engaged in sexual penetration with the child between 1st of January 2016 and the 31st of December 2016, and on the 6th of January 2017. At the material times, the child was 7 and 8 years old, respectively. Upon conviction, he was immediately sentenced by the trial judge to 2 concurrent life sentences without the possibility of parole before the expiry of 20 years. On appeal to the Court of Appeal, he contended that the sentences imposed, including the non-eligibility for parole requirements, were manifestly excessive. The Court of Appeal affirmed the imposition of his sentences. Before this court, the applicant applied for special leave to appeal the judgment of the Court of Appeal. He contended that the combined effect of manifestly excessive sentences and a flawed approach to the sentencing process, including the Court of Appeal's failure to review and correct them, amounted to a serious miscarriage of justice and justified the granting of special leave. The principal question for determination by this court was whether the applicant satisfied the requirements of special leave. According to the court, the questions to be answered to a standard of arguability were: 1, was the sentence imposed manifestly excessive? And 2, did the judicial sentencing process sufficiently meet acceptable fair hearing standards to avoid any serious miscarriage of justice? Examining the sentencing process of the trial judge, the court noted that in Pompey against the DPP, guidance was provided to trial judges on the best practice approaches to be taken on sentencing in cases involving sexual violence on minors. In Ramcharan against the DPP, the court affirmed these best practices with an expectation that they will be applied as and when appropriate. Ideally, this guidance ought to be followed to ensure that constitutional fair hearing standards are satisfied. However, failure to do so was not fatal. In this case, the trial judge did not receive a victim impact statement, sentenced the applicant immediately after the verdict was given, and did not consider a social services report. However, it was evident that the trial judge considered the aggravating factors placed before her, including the age of the complainant, the special relationship of trust between the applicant and the complainant, the lack of a guilty plea, the applicant's attempt to shift blame, the repeated course of conduct, and the consequential emotional damage to the complainant. Based on these, and after having heard and considered the applicant's plea in mitigation, the trial judge determined that in the exercise of her discretion, she could not be lenient. Her approach demonstrated an intention to consider and balance relevant sentencing factors, though not necessarily as fully as advised in Pompey and Ramcharan. Her sentencing remarks also show that the applicant's rehabilitation and reintegration into society were taken into account. With respect to the sentence, the court noted that life imprisonment was the maximum penalty under the relevant section of the Sexual Offences Act and was available within the range of punishment options available to the sentencing judge, where the sexual activity included sexual penetration. The court noted as well that the circumstances of the crime were well placed before the trial judge, who found no mitigating circumstances. Additionally, what made this case distinct in its severity was the special relationship of trust between the victim survivor and the perpetrator, and the young age of the victim survivor. Considering several precedents in which the crime of sexual activity with a minor was perpetrated by an adult in a position of trust, it was therefore fair to say that the choice of concurrent life sentences in this case was neither extraordinary or manifestly excessive. Indeed, it was reasonably arguable that life imprisonment in the circumstances of this case was well within the range of sentences that ought to be considered. Furthermore, it was also fair to say that the imposition of a 20-year period of ineligibility for parole was well within the existing range for similar cases. Considering the guidance in Allain against the Queen, it was open to the trial judge to conclude that the applicant deserved a sentence of life imprisonment. The crimes committed were among the most serious, and in this case included premeditation and involved coercion. The trial judge found no mitigating circumstances capable of lessening such a life sentence, and the applicant never offered an apology or showed any remorse. The psychological trauma to the victim survivor, though not investigated, can be presumed. While imprisonment for life was considered sufficient to punish and deter, the opportunity for eligibility for parole after serving 20 years with the necessary rehabilitation through counseling and therapeutic facilities available in prison provides the possibility for rehabilitation and reintegration in society within the applicant's lifetime, and so meets those sentencing objectives. So while the sentencing approaches and recommendations made in Pompey and Ramcharan were not precisely followed, it did not necessarily mean that the trial judge, in the exercise of a sentencing discretion, and the Court of Appeal in the review of the process, erred in law and in fact so as to create any serious manifest injustice or miscarriage of justice. In those circumstances, the application for special leave is dismissed and each party is ordered to bear their own costs. And we wish to thank all counsel for the great assistance that was provided to this court. Thank you very much. We may rise.
All rise.